November 17, 2015, Radnor Zoning Hearing Board. We have one matter for tonight, which is Appeal 2952. Prior to that, I'd like to ask everyone to stand and pledge of allegiance.
Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So we have one matter tonight. It's Appeal 2952. The applicant, Chris Fisher, property located at 220 Lowers Lane, Rosemont, PA 19010, appeals the enforcement notice issued by the Township Zoning Officer dated February 18, 2014. Applicant seeks a determination that the code section 280.115.2, student housing ordinance, is unconstitutional on its face and as applied to the applicant. Alternatively, the applicant contends that he is entitled to a special exception under the Student Housing Ordinance, Section 280.115.2. The applicant further contends that it is entitled to a variance from Section 115.2E and any other provision of the Student Housing Ordinance with which the applicant's property does not currently comply. In addition, the applicant contends that the existing use at the property qualifies as a lawful non-conforming use. Applicant further seeks any applicable variance or other relief required under zoning code, or contends that the present use is permitted of right. Is council present?
We are.
Are your monitors working?
They were having problems with
They were, okay. And we lost Kevin.
Yes.
Is he checking the monitors?
No, he's actually going to get his zoning.
Okay. They're not working? Okay. Good evening.
Mr. Chairman.
How are you?
Well, and you?
Great.
Good.
Great, great. I think pursuant to our communications, we'd like to deal with one set of matters first, and then defer any constitutionality discussion until after this matter is completed. So I'd like for you to put on a case regarding your special exception relief, your variance relief, anything required under the Pennsylvania Code.
Appreciate that. It was my impression that we were going to be dealing with the outstanding document discovery issues first.
I don't believe there's any outstanding document issues.
There very definitely are, and we raised them in emails. And there's an additional matter that has become apparent given the township's response to the subpoena that we think we need to raise as well. But as you know, in the emails that we sent to Mr. Ryan, and I believe, Mr. Chairman, you got copies of those, there were some questions about whether the township had complied with the subpoena. Township says it has fully complied. I know that's Mr. Nelson's argument, but there are a lot of documents that we should have gotten that we didn't get, and preliminarily, there was an artificial restriction contained in the subpoena that it has now become apparent should not have existed, because there are some very interesting things in the township's files relating to student housing uses that are outside the yellow circle on that one exhibit that was used during the last hearing. I guess preliminarily, there are a few things that we'd like to put into the record as exhibits. I think I indicated in one of my emails that I wanted to put into the record the email chain that included the zoning board's order of consideration, our response thereto, and then additional discussion regarding document production. We think that's an appropriate exhibit. We want it to be part of the record, and we don't think, unless there's any objection to it, we think the board should include it. I can hand that up as an exhibit.
Let me just, because I am anticipating, one is the email chain that at the very top has typo corrected, because I corrected a typo in the thing, and then it then goes to the main body, which is Dear Jim and Peter, and it says that we wish to proceed with the order of consideration. That email follows in the same chain. Your email objecting to that and asking that that objection be made part of the record, and then finally the order of consideration, and that would be one thing. The second thing are the forms of subpoenas. The two signed subpoenas I assume you want into the record.
We do, and we'd be happy to have those be board exhibits if you wish.
Well, we'll get to the labeling. Let's just get the documents as to who puts them in is less important what they are. There is a letter from Peter Nelson dated November 9th responding to your email.
Yes.
Then there is an
I actually have that, excuse me, I actually have that in the compilation of emails on these subjects that I have put together as an exhibit. I'm happy to,
okay, and then
happy
the
to
other
hand that up.
the other one is a response to this one picked up the email chain after you objected to the order of consideration, said here's a letter, and then an additional stuff, your response to Peter's letter.
Right.
So you can, I can, the board already has copies of these, and we could put them in right now. And frankly, why not put them in as board exhibits?
That's fine.
Yeah, can I hand up what I have as a compilation on the email that includes Mr. Nelson's letter, and you can look at that to see if you think it's adequately comprehensive. Can we do that?
Yeah, that's fine.
Okay, let's do that.
And on the, I guess while the solicitor is looking through the documents, the subpoenas were issued, at least according to Township Council. They have complied with that.
Sure.
I'm not at a point to make this case over did they or did they not. I'm prepared to put, I would ask Township's Council if they'd be willing to put Kevin Kachansky on the stand and ask him if he complied with the subpoenas. And if he says yes, then I think we should move on to the merits of the case.
I'd like to be heard on that because I want it to be part of the record. I think it's important that it be part of the record.
Okay.
And we're going to be here for probably a couple of hours tonight, so I'd like as much latitude as that before the board. To me, it's great that the township thinks they've complied, but there are a number of areas in which we have not gotten any documents, and I think we need to explore that. In particular, Mr. Chairman, if I may, let me just start with one thing, and then I want to get back into some of these others. As we noted in the emails, Exhibits T1 and T2 were not part of any file that was produced to us by the township. Mr. Nelson, in his letter, implies but does not explicitly state that those exhibits were in the property file. I can put Carl Fisher on to testify that when he reviewed that property file a year and a half ago, those documents were not in it. And I can testify that when I reviewed the property file on October 14th, which was nearly 4 weeks after the last hearing we had in this case, that those documents were not in the property file. So those documents had to come from somewhere, and it's our understanding that there's another file that has not been produced to us that may have other documents that are relevant to this property. If that's the case, there's no legal basis for the township to withhold them, either under the right to know law or under the subpoena that was issued by the board.
May I just back up for a second? My thing is actually a little more comprehensive than yours. It's everything that you have plus some. Why don't we do this? We'll put yours in because there's nothing wrong with duplication as applicant's exhibit. And what are we at for the applicant?
I don't know. Norma, do you know where we are on the exhibit number? Does anybody have a list?
My last one in my file is A6, but I don't know.
Pardon me?
We're up to A7 according to my records.
We're up to A7 would be the next one?
Yeah.
Thank you, Peter. All right, so ours would be,
Mr. Green?
yes,
What is A7? I'm sorry.
It's A7 that this exhibit that you submitted would be the correct numbering?
I'm happy to have that be A7.
Okay, that's A7. Okay, I'm going to put in the subpoenas themselves as A8 and 9, as signed by, no, sorry, B1. B1 and B2, okay?
Just for clarification, Mr. Ballman is B1 and the document subpoena is B2?
No, the other way around.
Okay, thank you.
Okay. Jim's email of I'm sorry. The train starts with my email of November 9th, 2015 at 5:10, which says at the top typo corrected, and then has the response with the typo corrected of the basically saying that we are going to utilize the order. Following that is an email in the same chain from you of Friday, November 6th, objecting to the order of consideration. I believe that's already in there.
Right.
And then following that is my email with the proposed order of consideration, and I'd like to make that B3. And I have copies for you if you need them.
That's all I asked for.
Okay, the letter of Peter Nelson dated November 9th, 2015, without the accompanying email, just a letter, I would propose to put in as B4.
B4?
B4.
I think that should be a township exhibit, but that's just my view.
Well, except I'm asking that they be put in now.
Okay.
Okay. I mean, I could, and I want to keep them together because, it's, I like the B exhibits to have a complete record. And then finally is your email chain. It starts at November 10th, 3:31 p.m. with a response to Peter's email, which attached the letter, which is not attached to this email, but it was a cover email by which Peter sent the letter. And then continuing with Friday, November 6, 9:46, your various objections to the order of consideration and my order, and then the order of consideration following that chain. And I would propose to make that B5.
That's fine.
Should we put those into the? Yes. And I can give you, we all have copies, but I can give you copies after the hearing, or I can give them now. I mean, whatever you want.
I don't know that I need them now, but I think this is all,
You have them right there. I'll
Yeah.
take them now.
Okay, let's,
Don't forget.
okay. Quickly make them up.
I would just need B3 and B5, just so I'm certain what's in there.
You know what, I've run out of copies.
If you have, I can get Peggy to.
Yeah, can I give you get the copies back with all the B exhibits and,
B exhibits.
yeah, and then they can be copied?
3, 4, 5?
Well, 4 is your letter, which I have, so I'm not worried about that. 3 and 5 is what I need.
No, I'm sure I can resurrect. Yeah, give me one copy,
Yeah.
actually. Give me a copy of that. I will take a copy if I can.
Okay, now I have another exhibit that I'd like to put in, which I guess would be A8, and that is the draft subpoena to the township that we submitted for the board's consideration before the issuance of B1.
This is-
Before we get further into this, just as far as what the board is planning, are we going to get to the constitutional issues tonight? I have a witness waiting here. I don't know. Okay. So,
We're going to hear the merits on the special exception, variance, any variance argument, and then we'll see where we are at that point.
okay, because if we're not going to, even if we decide to move forward, I'd like to be able to send them home if you decide, okay, okay.
Yeah,
Thank
I'll
you.
let you know when we know.
All right, thank you.
Briefly on the difference between A8 and B1, there's one essential difference that emerged as a concern. In paragraph 2 of Exhibit B1, which is the subpoena to the township that was ultimately issued by the board, the documents relating to determination of individual student housing uses was limited to those that were within the yellow perimeter on Township Exhibit T12. That is an artificial limitation that's not reasonable in light of the nature of the constitutional challenge that we've brought before the board. Our challenge relates to the application of the student housing use throughout the township, not within a narrow area circumscribed by a 1,000-foot perimeter around 220 Lowry's Lane. In fact, if there were instances in which other property owners outside that perimeter were given favorable treatment or were somehow treated differently from the owners of 220 Lowry's, that's directly relevant to the constitutional challenge. And as it turns out, and as we intend to show by putting in some documents a little later on this evening, there were properties outside that perimeter in which the township reacted favorably to pleas by student housing uses that they be allowed to continue under somewhat difficult circumstances. So we think that the limitation in the subpoena was unfortunate, that it was unfair, that we should be given full discovery of information relating to all the student housing uses in the township. And in fact, one of the documents that we do have is a spreadsheet that we believe lists all of the student housing uses in the township, and there are, haven't counted them, but I think there are probably about 50, somewhere in that neighborhood. But anyway, it's several multiples of the 14 properties for which we were given documents in response to the subpoena to the township. So this was the restrictions that this placed on us and the unfair nature of that were not immediately apparent when the board issued the subpoena, but it became quite apparent once we looked at the documents that were produced that it was not appropriate. And what we would like the board to do before the conclusion of this case is to reissue the subpoena that's Exhibit B1 to allow us to see documents relating to all the student housing uses in the township.
It's discretionary. This is not civil litigation. The rules of civil procedure. Thank you. Do not apply. It's to your discretion. You could issue it, you don't have to issue it, or you can issue a modified subpoena, which you did in this case. It's purely discretionary. There's absolutely no requirement to reissue it. There's no requirement of quote-unquote fairness. It's just purely discretionary. The township fully complied with the subpoena as it was issued. We provided them with all the documents. I have reviewed the documents we provided them. The letters that Mr. Greenfield says were not in the files, I saw. So I do not understand how he did not see them. I certainly cannot explain what happened a year and a half ago when Mr. Fisher did that. Furthermore, we are more than willing to put on testimony that we did fully comply with the subpoena, and we're willing to move forward that we did. And it's a delay tactic.
Yep,
We
so,
just- we
let me
need to
get,
go.
I appreciate it, and I apologize for cutting you off. I just want to get to the, kind of move this a little along. Subpoenas are as issued for right now, no change. I understand you got your issue on the record, I think by putting as well your emails, and all that, you have your arguments on the record as well. I think the only thing that I'd ask is exactly what you said. I'd like to have Kevin sworn in, testify that they comply with the subpoenas, and then I'd like to move to the merits of the case.
Well, that's fine, but if we're going to do that and have Kevin testify, I'm also going to want to have Carl Fisher testify that T1 and T2 were not in the township's property file when he reviewed it a year and a half ago. Mr. Nelson has said he can't explain if they weren't in there, why they weren't in there.
But the subpoena related to the
ask
latest
a
discovery. So while I appreciate the fact that he didn't see it a year and a half ago, the matter here is the subpoena that I issued this past month, and did the township comply? If they did, great. What happened a year and a half ago, what happened 5 years ago, is not, for me, is not relevant. It just isn't.
And those are right-to-know matters, and to be honest, this board does not have authority to review right-to-know responses.
Actually, that's not correct. Once we're into the realm of the board issuing a subpoena, I don't want to say right to know never applies, because I think the township should have given us these documents without a subpoena. But the point is that you're now talking about the parameters of a subpoena that are restricted in a way that prejudices our ability to prove a constitutional case.
Subpoena
So
was
it's not-
ordered.
We can't just say it's not a right to know, that it's a right to know matter.
The subpoena was ordered. I
Okay,
just want to
I
see if,
understand.
I want to know if the township complied, and then I want, again, if we have to be here for 5 hours, it's not an issue of timing. We have 2 dates. We have tonight, and we have the 30th on our calendar to hear this matter. I want to get to the merits, because
We
I
want
think
to
our
get to the
town,
mer-
I think the board deserves it, I think the residents deserve to start hearing this case.
Well, I think we also deserve the right to put on a complete case. And if Kevin is going to testify that the township complied with the subpoena, then I want to reserve the right to put Carl Fisher on to talk about what he saw in that property file a year and a half ago. That's only equitable. It's only fair. If you don't think
But
fairness
how is that,
important-
how is that relevant to the subpoena,
It's
the
relevant.
issuance of the subpoena?
It's relevant to compliance. We were never supplied with a file that contained T1 and T2. We have reason to believe there's a file. Where do the documents come
put it-
from
then
if
put-
they weren't in the property file?
Put it in the relevance of making your case for a variance, special exception, whatever, but not on the subpoena issue. Not with, did they comply with the subpoena? That's one, I want to get that resolved on the record and move to the merits. And if, to the extent that that testimony, whatever is relevant to you making your case, we will hear it. I
Well,
will
then-
not deny you that. But with regard to the issuance of the subpoena and the compliance of the subpoena, that this is the only matter. That's it.
So you're going to hear one witness and not bother to hear the other side on that issue?
What I'm caring about now is the subpoena that was issued, was it complied with by the township? That's the question.
And we have contrary testimony. But if all you want to do is hear one side, we're now on the record that we should have the right to counter that. If you don't want to, in fairness, give us the right to counter it, then go ahead.
How is your client testifying to something that happened a year and a half ago relevant to a compliance of a subpoena from 2 weeks ago?
The issue is whether T1 and T2 were in the property file. The
So if they were in the
township-
subpoena, in the subpoena in which the township supposedly complied, that's what I care about.
Well, right, but there are 2 of us on our side of the case that both looked at that property file, and we didn't see it. Now, the file was tiny. It might have been that thick.
So
I'm
he's
holding
going
my
to, he's going
hand
to.
about half an inch apart.
Let me clarify what you're saying. So you want to put on the record, he's going to testify that 2 weeks ago, when he looked at the file, things were missing.
No, a
Then
year and a half
that's-
ago, before the first hearing. So in other words, if there's going to be testimony that those documents were taken from the property file and shortly before the last hearing and used as evidence, Mr. Fisher's testimony would tend to show that's not true. So.
Peter, would you mind putting Kevin on the stand, please?
Go ahead.
Sure.
Where would you like him to stand?
In case we have a camera?
This is being recorded, correct?
I don't know. It's not.
Video is not.
You do solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your name for the record.
Kevin Kuchansky.
Mr. Kuchansky, are you familiar with the subpoena that's been previously marked as Exhibit B1?
I am.
And is it your testimony, where is this? Thank you. Is it your testimony that the township fully complied with that subpoena?
Yes, it is.
And can you explain to the board how township keeps files on properties?
We have 3 different locations where the files are kept. 2 are electronically and 1 is a paper copy. The paper copy consists of old files, pre-2000 timeframe. The electronic files are in our Laserfish archiving system and then on a local server, our ComDev server. So between those 3 locations are where our files are kept.
And were all 3 locations of files provided in response to this subpoena?
Yes, we provided the paper copy, and then on a thumb drive, we provided copies of all the electronic documents.
Is there any separate enforcement file that the township keeps on 220 Lowry's or on any property in the township?
There is not.
So all documents relating to 220 Lowry's or any other property in the township are kept in that property's specific property file?
Correct.
And once again, you provided all the documents in your possession, in the township's possession, in responsive to the subpoena.
I did.
Thank you.
Thank you.
May I cross-examine?
Sure.
Mr. Kuchansky, did you pull exhibits T1 and T2 at some point to give to Mr. Nelson for use in this case?
We make copies of our files, but they're copies from that T1 and T2, I believe, which are the T1 and T. I believe they're the enforcement notices.
One is no, let me show them to you. Give me a moment. Yes, T1 was the letter from Mr. Blake to Mr. Fisher, dated April 23rd, 2004. And T2 was the letter from Mr. Blake to Mike Flagg, dated June 3rd, 2004. Where did those documents come from?
Those documents exist in our Laserfish system. In the Laserfish?
So not in the property file then, correct?
Not in the paper file, no.
And have there been any applications for student housing that have been rejected by the township since the passage of the ordinance?
Objection. This has nothing to do with responsiveness to this.
Sustained.
Let me again represent to the board that we asked for the.
You're asking for a cross here, so do your cross.
I'm going to do it, but I want to make my point first for the record. We asked for, and the board ordered produced, documents relating to student housing applications that may have been denied. We got none of those. So my question to the witness relates to the township's compliance with the subpoena.
And he then Asked
We've
and
already
answered.
tested
How about
them.
that?
Well, no,
Yes.
the question has not been asked. I did not, no one specifically asked him whether the township denied any applications. If they didn't, then he's answered the question. If they did, then the documents haven't been produced.
No, he's assuming that there would be documents in relation to a denial. He's putting assumptions into the record and then asking questions based on those. This entire argument is based on the fact that he's saying, well, we have not found these letters when we researched the file. Ergo, the township must be hiding them, along with a whole bunch of unknown documents that's going to help our case. There's absolutely no proof that this is happening. In fact, I specifically asked Mr. Greenfield, when I told him the documents were ready, to contact me if he had any problems. He did not contact me.
Okay, yeah, I get it. I think we're, unless you have any further cross, I mean, I think he's gotten on the record, I think what I would like for him to get on the record, that the township did comply. So again, if you have any cross, that's fine. If you have some new points to bring up, I suggest that you bring it up into your case.
So you're saying that it's not a fair question whether the township ever denied a student housing application since 2011? How is that not relevant?
Again, the examination related to compliance with the subpoena.
Exactly, and that question
Did you
goes
ask?
directly to that issue.
It does not get directly to that
Yeah,
issue.
yes, it does,
not.
because if there were denials and they weren't produced, it goes to compliance.
But did you comply with the subpoena?
To the best of my knowledge, yes.
All right, so you're going to cut off my cross there? So we're on the record on that. Okay, that's fine.
That's fine.
May I now put Mr. Fisher on? Again, his testimony is going, on this issue, is going to, on this limited issue.
Mr. Chairman, what Mr. Greenfield said previously was Mr. Fisher was going to say he didn't see these letters in a file a year and a half ago, and I thought the testimony was they weren't in the file. So I don't understand why we want to take our time to hear this, because it doesn't seem to be relevant in response to that testimony.
I think that's a fair summary of the
Actually, I
testimony by
think the
Mr.
statement
Martin. We'll
was that
accept
the file resides in 3 locations, one of which your client may have had, the other 2 of which he may never have seen. So to say that the letter wasn't in the file because he didn't see it in a paper file is not necessarily accurate, because I believe the testimony is that the file resides in 3 places.
Well, no, I mean, if his testimony is that he didn't see it in the paper file that he was given, that would be accurate and would be consistent with Mr. Kachansky's testimony.
Well, but I don't think it's consistent with your notion that somehow it wasn't provided, unless you were denied access to the electronic files.
I did receive some electronic files, but I didn't receive any that had T1 and T2 in them. So the question then is, where were they? I just want to make that point on the record. If you want me to be sworn to say that on the record, I'm happy to do it.
I don't think that's appropriate to have the attorney of record to become a witness.
It happens all the time, constantly. That's all right. I will state, as an officer of the court, as an officer before this board, on the record, that there were no documents produced to me that contained T1 and T2, just so it's on the record.
Great, thank you.
But for the record, you have a copy of T1 and T2.
Sure, which I received at this hearing and saw for the first, not at this hearing, in the September 18th
Thank you.
hearing, saw for the first time that night, yes.
All right, so again, you're gonna start your arguments for any claims under Pennsylvania law, including special exception, variance, estoppel.
Yes.
Nothing related to the constitutionality issue.
If the board doesn't want to go there at this time,
Not at this
that's
point.
fine. We
That's-
think that
Our process that we're going to follow is, just like I said, if you veer off that, I will stop and make sure we get back on track. It's just an order of precedence that we need to be organized since there's so many issues here. I want to get through these issues first, then deal with the constitutionality second.
Okay. Preliminarily,
We are done with the subpoena issue at this point in time?
That is correct.
Thank you.
preliminarily, in response to the board's order of consideration, I should note that one of the things that the board anticipated was that we would be making a case for relief from the provisions of the underlying R4 zoning restrictions. We did not appeal on that basis because we were not cited for any violations of R4. What we were cited for was a violation of an ordinance of general application, which was the student housing ordinance. So we're not prepared to go forward on R4. We don't think we should have to bear that burden because it was not in our application. And frankly, if that's a place where the board thinks we need to go, then we need to re-advertise. And I know the board doesn't want to do that. So that's not, in our view, an issue that's before the board.
That's fine.
If I may interject, in order to get the special exception, they must show compliance with all applicable ordinance provisions, including the R4 provisions. So I don't understand how we can just skip over those and say, you know, they don't need to address those, or at least show that they either can meet them or they're requesting variances to them. I believe the application asks for one specific variance and then asks for anything else they may need, which in another day I might argue is improper, but at this point in time, I think certainly opens this up to anything they may need.
It's my recollection that the board has, raised this sua sponte, and that the issue is fairly on the table and fairly joined, and that we, are going to consider whether, you need a variance. The facial constitutionality of the ordinance comes after a consideration of whether you comply under state law, and I would allow you latitude of discriminatory enforcement on some sort of a due process theory under the federal constitution, although candidly, the very few federal cases I know don't get anywhere near this, but the facial constitutionality, if you are unable to get relief with respect to the underlying zoning, including a claim of some sort of discriminatory enforcement, I think a variance based on estoppel is the likeliest home for your theory. But we're talking about as applied discriminatory enforcement. You're picking on me, all of those theories. And those, Mr. Chairman, I think need to be addressed before we even look at the facial challenge.
I think there is already some evidence in the record on variance by estoppel, which is the township's acknowledgement back in, I guess, 2004, 2003, somewhere in there, that, and this is T1 and T2, that it had noted that there might be a violation of township ordinance inherent in the student housing use that was already in place since 2002 at 220 Lowry's, and yet the township, despite that acknowledgement, in effect allowed the use to continue for another 12 or 13, 10 or 11
Yeah, but that was
years
done
before
on
anybody said anything.
that was done on the written representation of your client that the people were related.
There was
There was
not
testimony. I'm sure there was testimony. I'll look at the.
a written representation? I don't think so.
You testified on the record though that they did not, and that David Blake gave a subsequent letter saying, I guess it was David Blake in the second letter, that based on the assurances that related people were living there, there wasn't a violation.
Well, that's David Blake's representation to the Director of Community Development for the township. It's not a representation that my client made.
Your client, though, did testify on the record that was true.
He testified that in the early days that most of the people who lived there were related. Yes, that's true. He didn't, I don't think there was any representation that it would be that way forevermore.
Well, I think.
Excuse me, Mr. Chairman. I think we're kind of floating around here without sufficient focus. And I would ask, perhaps we could ask Mr. Greenfield there is some inherent logic to say either you are seeking a special exception or you're deciding not to do that, or you're arguing that there's variance by estoppel. I mean, could you be a
Sure.
little bit more direct and so we know where you're going? Are you going to put on your witnesses to make those arguments or just refer to the record as it exists from our prior hearing?
Yes, I think rather than rely upon either a variance or special exception request under the student housing ordinance, we rely either upon the nonconforming use argument that we've already made and the board has already ruled upon, and also upon the variance by estoppel argument. Now, I also want to say, Matt Baumann is here. He's been waiting patiently, and he's here pursuant to subpoena, so I would like to get his testimony on so he can go home.
Related to your argument for what relief?
Primarily related, it's going to primarily be relating to the constitutional issues.
Well, the facial issues or the enforcement?
The enforcement issue.
Makes sense.
This is the variations on various by statute.
Yeah, or, you know, they're
Okay, that's fine. Let's, you can continue.
Okay.
Mr. Baumann. Mr. Baumann, before you get on, so just so it's clear to the board, because do like Bill's statement for clarity here. So you're not going to be going for a special exception, you're not going to be going for a variance, you're just going to be leading with this?
That's our intention at this
Okay,
time, yes.
thank you.
Raise your hand. You just solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
And state your full name for the record, please.
Matt Baumann, B-A-U-M-A-N-N.
Mr. Baumann, are you the former Director of Community Development for Radnor Township?
Yes.
During what years were you employed by Radnor?
Approximately, it was December of '04 to June of 2011.
And during which portion of that period were you Director of Community Development?
Approximately years 2009, 10, and 11.
So you were then the Director of Community Development at the time the Student Housing Ordinance was passed in 2011?
I was, yes.
And you were involved in that process?
Yes, I was.
I think our next exhibit's A9, is that right?
yes.
Excuse me a moment.
Okay.
Mr. Baumann, I want you to look at Exhibit A9. That's a letter dated February 17th, 2011, on the letterhead of the Delaware County Planning Commission. Is that a document that the township received?
My recollection is, yes, this would be a document that the township received.
And did you understand that to be the Delaware County Planning Commission's review of the proposed ordinance, which is a step required by statute?
Yes.
Do you recall, let me direct your attention if I may. Did you understand from this document that the Delaware County Planning Commission was noting that the restriction to 2 students per dwelling unit was inconsistent with what Haverford Township and Lower Merion Township were doing?
I don't recall, but if I could take a second
Sure.
to review that to refresh my memory here. Do you know where that says?
Yeah,
that?
maybe before that. Let me see.
Mr. Chairman, I have a question. The legislative history, if you will, or the comment process through various bodies relates to enforcement. How?
I'm going to let him go a little bit more. I agree
Okay,
with
thank you.
Yes.
This
Thank you
may
for
be
bringing it up.
the only line of questioning I have that would relate more toward the facial validity rather than the enforcement issue.
Correct. I agree with that, with this statement here in the letter.
So there was a difference between the restriction as Radnor proposed and what,
Could we, at least for the sake of the record, have a description of what statement he's agreeing to within the letter, the location within the letter?
sure,
It
I'll
just-
read it into the record, then I'm happy to do that. This is it, this is the last sentence on page 4 of the report. And it states, "The township should, however, consider allowing a maximum of 3 students per student home, which is consistent with both Haverford and Lower Merion Township's ordinances."
I would agree with that.
Yes. Was there, subsequent to the township's receipt of that report from the Delaware County Planning Commission, was there any further discussion as to whether that restriction should be 3 or 2 students?
I don't recall exactly, but where I work now in 2 different townships, consistent with, there's 3 there, so I've been trained to sort of from the courts to that 3 is the number proven by the courts, and I don't recall specifically the council.
He's not an attorney, he can't testify as to what the legal ramifications of either of these court cases are.
He's saying
And
what
further-
his understanding is.
Sustained.
Continue.
Sure.
Okay. So I would have worked with the solicitor to change that from 2 to 3 to be more consistent.
Now, Mr. Baumann, after the ordinance was adopted, did you participate in a determination by the township as to whether existing student housing uses should be permitted to continue?
The ones that we have currently that were at the time that had a registered student license, should they continue? Is that the question?
Well, the question is, which uses did you look at to determine whether they should continue, and what were your criteria?
Well, my recollection, number one, if they're a registered student home, and we had student defined at the time, I believe. And yeah, I'm sorry. So that was the first criteria. The second criteria was coming up with a spatial delineation of separation of that because of the concern of the density, the number of student housings existing in this particular area, which is Carrot Hill. So working with the solicitor, again, with his advice, we came up with a spatial determination to that, in his opinion, would have been tested by the courts and proven valid. That's as far as I remember. I remember we worked back and forth in creating maps, just what type of impact that would have had, therefore creating a lot of nonconformities, again, as a result of this. And so we went back and forth on that, and this was approximately spring of 2011.
So this was before the ordinance was approved?
Correct. This was before, this is working with the Planning Commission, this is going through that process, this is during that time period.
And when you created the maps that you referred to a moment ago, what did you do with those maps in terms of filing them or making a record of them?
Well, I think, and I can't speak, I'm not 100% certain on this, but it was number one, we needed an exhibit for the Planning Commission. They needed to see something, and ultimately the Board of Commissioners would have needed that exhibit as well. So at the time, we used a program called Map Info. It's a GIS, it's a mapping program. Taking that from Excel, bridging that into Map Info, and seeing it on paper, spatially defined, and then taking that also and sending to the county. So we needed these exhibits as important evidence to the what type of ordinance we're actually creating.
And in preparing those exhibits to show both the township and the county planning commissions, did you make paper copies of them?
Oh, absolutely. We would. We always make. We don't. Yeah, we would print them out and store them and use them exhibits and things like that, and post them on our website as well.
And after that process was complete, what became of those paper exhibits?
That's a very good question. I'm not able to answer that question. I don't recall. Maybe the county might have them. I don't.
Objection. Witness says he doesn't know. He can't be guessing.
You don't recall having filed them anywhere?
I don't personally recall.
Objection. How does this relate to a constitutional challenge?
I agree.
Let's go back, Mr. Baumann, to our discussion of what happened after the ordinance was approved. Did you then make any similar maps or documents to begin the process of determining which of the existing uses should be allowed to continue?
So you're asking if this post-adoption by the board codified at this point? No, we wouldn't have made any more exhibits. My recollection, no, we wouldn't have.
It's, you referred a moment ago to the proximity limitation in the ordinance. You're referring to the 1,000-foot limitation, correct?
I believe that's what was that was adopted.
And it's correct, is it not, that after approval of the ordinance, you knew that some of these student houses were going to be well within 1,000 feet of others?
Absolutely, 100%. That would have created a lot of nonconformities there.
Did you at any time attempt to determine whether there were other pre-existing student housing uses that had not been registered with the township?
There were conversations with that with the solicitor, and I don't recall what our action was at that point, but it's like any sort of post-adoption. There could create nonconformities or not. It depends who submitted permits, who submitted proper documentation. That's always going to happen in any municipality adopts a local zoning ordinance.
Okay. So, to your knowledge, were there any student housing uses in the township post-approval of the ordinance that were not registered with the township?
I was not there long enough. Can you relate? I don't recall when it was formally adopted. Do you know the time period on that?
April, May of 2011?
Yeah, I left in June of, so it only would have been 45 days or so afterwards, so I don't recall any of that coming across my desk.
Were you still with the township in July of 2011?
It's interesting. So July of 2011, I'm trying to think of when I started over in Tredyffrin. It must have been literally, that was probably one of my last days.
Okay. Do you recall a discussion regarding student housing in a collection of dwellings owned by Joan Baribault?
Joan Baribault owns several in Garrett Hill.
Okay. Let me show you, let's mark this. We're up to A10.
So Matt, just for the record, you're telling us that you were employed in July?
I was. I'm sorry. I thought it was June, and
Do you have an exact date?
if this is that Friday, I think it was probably this last day, right? July 8th.
July, okay.
Mr. Baumann, Exhibit A10 is an email that appears was sent by you on July 8th, 2011 to Joan Barabalt. Do you recognize that email?
I do.
And what can you tell us, please, what was the process that led up to that?
Dear Joan, thank you for providing the historical leases for the above noted addresses. The township is satisfied that you have provided evidence documenting that historically you have rented to 3 students and therefore considered grandfathered, in other words, non-conforming. Please note, however, that at any other property in which you wish to rent, the maximum number of students may not exceed 2. So the essence here is, again, working with the solicitor at the time, was to ensure that over a period of time, X amount of years, and I don't recall the years that Joan rented these, but there were many years that as long as you didn't vacate that use, the township was satisfied at the time that that use could continue as a grandfathered use.
Okay.
Mr. Baumann, was that determination made, looking at the existing zoning and determining whether the rental use predated the existing zoning?
That's correct. It was looking at the existing, the updated ordinance, if you will, that was passed in that year and comparing that historically. Yes, so it was using the new ordinance in place.
Yeah, but what about the existing? Was there any inquiry as to the existing zoning of these properties?
Outside of the student housing ordinance?
Yes.
And applying other factors in that?
Yeah, I mean, non-conforming grandfathering should be, was the use legal at some point before, either under the existing zoning or whether it was under the zoning when it's commenced and then there was
That's
a
a good
change?
point. At some point prior, I do recall that the argument was made that at one point that was a conforming use that predated this particular ordinance as well.
Okay.
And others.
Mr. Baumann, do you remember if Joan had a license to rent?
At this location or any location she has? At this one?
I don't know what this location is, so.
It's 2 of them, Rockingham
Okay.
and Bryn Mawr.
She was, in my recollection, she was very good at providing leases to us and rental licenses to us each and every year.
Just an interruption, A10 is the email from Baumann, and this is A11?
The email is A10, right, and the leases are A11.
So based on that fact, these properties would have been in your map?
My recollection, they would have been.
Okay.
Mr. Baumann, following up on the question that Mr. Ryan asked you, is it correct that as of 2011, if a student home had 3 unrelated students living in it, that would have not been in compliance with R4, correct?
If it was 2 at the time, no, it wouldn't have been. It wouldn't have been in compliance.
If it was more than 2.
If it was more than 2 unrelated, correct.
Okay, thank you. Exhibit A11, can you tell us, please, what that is and whether it related to Exhibit A10?
This is a lease with the property owner, Joan Barabalt, for, I'm sorry if I can't, that's associated with 214, I believe that says, Rockingham Road. So it would have been a lease, and I believe the year,
It's hard to read
this
that.
says 2009. So it wouldn't have applied to this particular email. I guess it would have been 2 calendar years or at least 1 student calendar year prior.
Looks like there may be
There may be more.
couple of leases here, correct?
Yes, that would have been the following year, 2010 and 2011, that student year, which would have coincided with this particular email.
Do you remember whether Mrs. Barabalt supplied any additional earlier leases to establish the prior existence of her student housing use?
Yes, I would have required more than 2 years of demonstrating historically a pattern of leasing over time rather than just 2 years. And I don't recall the note, but it would have been more than 2.
You're not sure how many years you would have required?
I don't, but yeah, definitely more than 2.
And fair to say that these leases in A11 showed 3 students renting the property?
Correct.
Is it showing also here that 2 of the students are related?
I'll take a
It
look.
says 2 people are related as cousins, and then on the second lease, in the middle, it says, with each of their parents to co-sign as guarantors, 2 tenants are related. So it
Ye-
looks like 2 of the tenants are related and 1 is not, which sounds like
That would have been
family dwelling is fine.
Correct.
So R4 compliance.
Correct.
Did you require proof at that time that, in fact, students were related?
Yes.
And what was the form of proof that the township accepted to establish that?
Joan Barabald in particular was very good about providing and redacting. My recollection is either affidavits or birth certificates at the time as a demonstration that they are related.
Okay. And the township was satisfied with affidavits and birth certificates?
Yes.
Would birth certificates, to your knowledge, show cousins?
It's a good question. They may or may not. I don't recall exactly what our criteria was, other than with her verification of, and through various things, if it was cousins, sisters, cousins most likely not, but sisters, brothers. I don't recall exactly the type of family connection we would determine that way through various documents, but we would ask for more than a lease.
And the affidavit would be satisfactory as well?
Yes, it would be.
All right. Do you recall during the time that you were with the township after the ordinance was approved, the student housing ordinance, whether there were any applications for student housing use, for new student housing uses?
After the adoption of this ordinance?
Right.
Nothing came in my recollection between the adoption and the time I left. My recollection, no, nothing came in. And they would have gone to the zoning hearing board, so.
Do you recall whether there were any other properties where questions similar to those in Mrs. Barabalt's case were raised?
I'm sure there were, but I don't recall. I don't recall the property nor the exact location.
Okay. That's all I have for Mr. Baumann.
Cross?
Mr. Baumann, how are you?
How are you?
Good, thanks. As the zoning hearing board chair pointed out, looking at Exhibit A11 on the 4th page, there's a reference to saying cousins, correct?
Correct.
And then on the 5th page, on that lease, there's a reference saying related cousins.
Correct.
Isn't it true the reason why Mrs. Barebolt was able to rent to 3 students was that she was, 2 of those 3 students were always related?
That's correct.
And there was in all those cases where we said you were fined renting to 3.
Yes.
Or we, meaning the township, it was because there was 2 related students in that.
Yes, that's correct.
And so there was actually only 1 unrelated student in those various student rentals.
Yes.
Is it also true that all of Mrs. Barabolt's rentals were licensed rentals before the adoption of these zoning amendments in 2011?
Yes, they were.
Regarding the A9, the Delaware County Planning Commission letter, if we turn to page 3 of this document, if you read under background, does this letter state, quote, currently the student housing regulations are contained in Part 2 General Regulations, Chapter 226 of the Township Code, where, under the existing definition of student tenant, a maximum of 2 students may reside in a home for a student rental.
Yes, it says that.
And that was correct, that prior to the adoption of the student rental provisions in 2011, there was already provisions in the zoning code that limited the number of students living in a house to 2 unrelated students.
I agree with that, but I need a clarification, and I don't recall. Is Chapter 226, is that the
That's
Radnor
the zoning code. Yes, that is the zoning
Then I
code.
would agree with that.
Wait, I object. Chapter 226 is not the zoning code.
That's what I thought. I thought it was 280.
Sorry? Oh, I'm sorry, my mistake, yes. That's the rental properties.
Correct. That's what I would agree with that.
Okay. And turning to the second to last page, I think it's the 5th page of this document, under conclusion. Isn't it true that the Delaware County Planning Commission stated in the conclusion that, quote, drafting sensible student housing regulations that allow sufficient supply while protecting community character is a delicate balance. Accessory vehicular parking and increased noise levels associated with late-night student partying are 2 of the primary issues which can adversely affect residential character. Accordingly, preserving residential character requires comprehensive regulations, which the proposed amendment appears to contain. Does the letter state that?
It does, yes.
I would like to introduce, and now I have to look up to see where we stand as far as township exhibits, if you give me a second.
Sure.
I believe your next one is 15.
I have
16 is my next
Yeah, I
one.
have
Yes,
215,
I'm
it's the
sorry.
280, yep.
Stand corrected.
So I would like to mark as Exhibit T16 another letter from the Delaware County Planning Commission dated November 18th, 2010.
What's the number of this, Peter?
T16, 16.
Thank you.
We're not going after legislative intent, are we?
No.
Okay.
Oh, of course, I did have extras. Here we go. Thank you. Mr. Baumann, do you recognize this document?
I do.
And like Exhibit A9, is this a letter from the Delaware Planning Commission to the township regarding the zoning amendments for student rentals?
Yes.
And if you turn to the 5th page of this document, under conclusion, does Planning Commission conclude, quote, regulating student housing within residential neighborhoods is a challenging though necessary endeavor to safeguard against ancillary activities associated with student living negatively affecting community character.
Yes.
And it goes on to say documented issues pertain to insufficient parking and noise associated with student partings.
Yes.
For these reasons, limiting the number of students per home and the number of student homes within a geographic area is warranted.
Yes.
Where are you reading from?
That would be on page 5 of Exhibit T16 under conclusion. And just to recognize, T16 contains actually 2 letters from the Delaware County Planning Commission. The one dated November 18th, 2010, and then the second one, which has already been admitted as Exhibit A9.
Oh, sure.
1 second, please. I'm done with my cross-examination. Thank you.
Thank you. Anything further?
I have just a couple of more questions for Mr. Baumann. First, Mr. Baumann, going back to Exhibit A10, even though it was your understanding that Mrs. Barabalt had related people living in her student homes, your instruction to her, your advice to her in Exhibit A10 that she could have 3 students made no reference to that, correct?
In that particular email, correct.
So as far as you were concerned, she was authorized to have 3 students there.
Correct.
Now, if I take you back for a moment to Exhibit T16 that Mr. Nelson just showed you, just above the conclusion on the very same page, the first paragraph under comment recommendation, would you please take a moment to read that to yourself, and then I'll ask you a question about it, rather than read it into the record.
What area again?
We're again on the 5th page of Exhibit T, I
Okay.
think it's 16, first paragraph at the top, under comment recommendations.
Read it.
Mr. Baumann, after this report came back from the Delaware County Planning Commission, do you recall any discussion about whether the township should change the requirement in the draft ordinance that a property owner provide proof that students were not engaging in illegal conduct?
I don't recall any conversation about that.
Do you know whether that draft language was ever changed?
From that particular date,
Yeah, if you look at the prior paragraph, right at the end of the last bullet point at the end of page 4, do you recall if that language changed?
my recollection is that did not make it into the adopted ordinance.
That paragraph that was not in the final version?
Correct.
Okay. All right, that's all I have.
Thank you.
Mr. Baumann, your testimony earlier was that, you, on the Barabalt properties, that you examined the history and, in particular, obtained proof that at least 2 of the students were related, right?
Correct.
So the statement that it says 3 students of any sort, all unrelated, has to be taken against a inquiry that you made that in fact 2 of the students were related.
In that particular email I wrote?
Yeah,
Well, it
yeah.
doesn't say unrelated in that email, it just says 3 students.
Yeah, but you did that, you made that, your testimony was you made that decision on the basis of satisfying yourself the 2 students were related.
Those particular 2 leases, correct. Previously, I can't testify to that, though.
Okay. No.
Any other questions?
We do have some recrosses. Sorry.
Great.
Mr. Bowman, in regards to the Barebolt properties,
Yes.
Isn't it true that there was a series of correspondences back and forth between my office and you concerning these properties and concerning the relationship between the tenants on these properties?
Many conversations back and forth with the solicitor at the time.
And those conversations had to do with Mrs. Barebolt providing proof that 2 out of the 3 tenants were related to each other.
That's correct, over and over. There was a neighbor that was very vocal at the time, and my position was at the time that we needed proper evidence to proceed ahead with this, and any sort of grandfathering in, we would have to have everything documented.
And that there's other correspondence that was provided to Mrs. Barebolt to that effect, that she had to, the only way she could get 3 tenants into these properties was if 2 of them were related.
Correct.
And that your email that has been admitted as Exhibit A, I don't have it in front of me, I think A9, does not supersede or change the fact that Mrs. Barebolt would have to prove that 2 of the 3 tenants were related in order for her to have 3 tenants in these student rentals.
I would agree with that.
Thank you. That is all.
Do you know whether any further inquiries were made of Mrs. Barebolt as to whether her tenants were related?
After that period?
Yep.
No, I don't recall that there were any.
Okay, that's all I have.
Any questions? Thank you very much, Mr. Bowman.
Thanks, Matt.
Peter, he's excused, right? You're good? All right, yeah, he's good.
We call Mr. Kachansky as our next witness. I think you're already sworn, so don't have to worry about that. Our next exhibit number is A12. Mark this. I'm going to show you Exhibit A12 and ask you to please take a look at that while I hand out copies. Mr. Kachansky, have you had an opportunity to review Exhibit A12?
I have.
Do you know what it is?
Looks like it's a list of properties.
Do you know whether that's a list of student housing uses that currently exist in the township?
I do not.
I can represent to you that this document came out of township files with a heading that indicated that it was student housing uses. Do you see any properties on this list that, to your knowledge, are not student housing uses?
Without looking at our system to verify each of the properties, I don't know that that's accurate.
You don't know one way or the other?
No.
Okay.
Mr. Greenfield, can I interrupt you for a second?
Sure.
I'm confused by your reference. It came out of the files with a heading, which is not on there now.
Yeah, because it didn't, unfortunately, it was a spreadsheet document on which the heading did not reproduce when I printed it. And I couldn't get it to reproduce.
It was a spreadsheet document.
Yeah, this is an Excel document that was produced to me by the township. And when I got the electronic file and went to print it out, the heading unfortunately did not print out.
Okay, so you weren't handed the paper document, you were handed
That's
electronic.
correct. I was sent an electronic document.
And just for clarity purposes, again, how was it identified electronically?
I can't remember the precise phrase, but it was something about a list of student housing uses.
Thank you.
Mr. Kachansky, do you know about how many student housing uses there are in the township?
Uses or properties or units?
Let's say properties or units currently.
Somewhere over 60.
Okay, there are about 120 properties on this list. Are you familiar with all the existing student housing uses?
Uses or properties?
Again, properties is fine if you want to adopt that.
Not each and every one. I'm aware of a variety of different student rentals in the township.
Okay. It's going to be A13 if you want to take a look. Have you seen Exhibit A13 before?
I have.
That's a letter that you sent to the Barrico Family Trust in August of 2013,
Correct.
and that was addressed to Mrs. Barabalt, correct?
Yes.
Relating to 214 Rockingham.
Yes.
And you were on that occasion citing her for a violation of the student housing ordinance?
I was.
Specifically, what was the violation for which you were citing her at that property?
That there were more than 2 students that were at the property.
Subsequent to that, did you have any discussions with Mrs. Barabalt about whether she was in compliance?
Prior or post?
After.
After, I'm sure we did.
Before you issued that violation notice to her, did you go back and check the township files to see if there had been any prior correspondence about her right to have 3 students on the property?
There was a significant amount of correspondence, as was testified earlier, regarding the relationship of the students with respect to there being more than 2 in her properties.
And what was it that prompted you to send this notice to her?
We probably received a complaint from a neighbor.
Before sending the notice, did you ask for any documentation from Mrs. Barabalt as to whether the students who were living on the property were related?
I'm sure I did.
And did you receive such documentation before you sent the notice?
If I would have received it before, then I wouldn't have sent the notice.
Okay. Did you subsequently receive documentation from her on that issue?
I don't recall specifically, but I believe I did.
Do you know whether the student housing use continues at 214 Rockingham?
Without looking at our system, I don't know for certain.
take a look, please, at A14. I'll be right back.
Okay.
You've completed your review of Exhibit A14.
Yes.
What was that document? Is that a document that you saw in relation to 214 Rockingham?
It appears to be a series of documents relating to, it looks like multiple parcels for leases. I see 289 South Bryn Mawr Avenue, one here. It's difficult to read this copy of this document.
So there are some other properties other than 214 Rockingham that are included in that exhibit, right?
It would appear so.
Right, so does that cause you to recall that you may have issued enforcement notices relating to properties other than 214, which were owned by Mrs. Baribault?
I know Mrs. Baribault has several properties that this exemption applied to, that she had previously provided documentation to the township regarding two of her student tenants being related.
Okay, do you recall whether you issued enforcement notices on any of those other properties? Particularly the ones that are mentioned in that Exhibit A14?
I believe I did.
Okay, so one of those was 298 Bryn Mawr, is that right?
Yes.
And were there any other properties represented in that exhibit?
I don't recall seeing any. It just appears that it's 289 South Bryn Mawr and 214 Rockingham.
Is it 289 or 298? I just want to make sure.
298.
298 South Bryn Mawr Avenue. Did you request any other, well, first of all, did you, how far back did you ask Mrs. Baribault to provide leases to show the use of the property?
I don't believe I required her to provide leases. I would have to take a look at the correspondence back and forth to see how we address the issue.
Okay, do you know, as you stand here today, whether you asked for any other documentation to satisfy you that the use was proper?
I would have required Ms. Baribault to provide documentation to prove relationship amongst the tenants and left it up to her to provide what she felt was sufficient.
Okay. Okay, this will be A15. I'll take a look. Please let me know when you've finished your review of that document.
Okay.
You've had an opportunity to review Exhibit A15, right?
Yes.
Can you tell us what that is, please?
These are a series of affidavits that Joan had provided to us outlining the relationship between at least two of the students in each of her properties.
And there are 4 properties covered by that set of affidavits, correct?
5.
5 properties. And in addition to, is 298 South Bryn Mawr one of the properties?
Yes, it is.
And 214 Rockingham as well, correct?
Yes, it is.
And the other properties covered are 241 Callanan, 245 Callanan, and 249 Callanan?
Correct.
Okay. All of the Callanan properties and the Bryn Mawr Avenue property, by the way, are more than 1,000 feet from 220 Lowry's, correct?
I don't know that for certain without seeing a map and
I'll show you what's previously been marked as T12, which I believe you testified showed the 1,000-foot radius around 220 Lowry's, correct?
yes, it does.
And the 4 properties that I just mentioned, the 3 on Callanan and the 1 on South Bryn Mawr, are all outside that yellow radius, right?
I see the properties on Callanan specifically being outside. I cannot identify on here if South Bryn Mawr Avenue is on this. My knowledge of the township, I do not believe that this area encompasses South Bryn Mawr Avenue within that radius.
South Bryn Mawr is even further away than Callanan, right?
I believe it is.
Yes. Okay. All the way over there in Ward 5. And is it fair to say that you were satisfied with the documentation that you received from Mrs. Barabolt as indicated in Exhibits A14 and A15 that she did not have more than 2 unrelated students living in those properties?
Based on the previous determination that she was allowed to have 3 students, 2 of which being related, the documentation that she provided satisfied that requirement.
You did not ask for any additional documentation that any of the students were related?
There was a series of communications back and forth as to what to provide. I don't know if this was the first thing that she provided or the last thing that she provided.
When you say this, you mean the affidavits?
The affidavit, correct.
Okay. But beyond the affidavits and then the leases that are indicated in A14, do you recall having received any other documents on that issue?
Again, there was a whole series of correspondence that had gone back and forth at that point in time.
Written correspondence?
It could have been through email.
Could have been through email, okay. But in some written form, right?
Email and phone conversations.
Okay.
This is 816, I assume?
16, I think. Mr. Kachansky, you have Exhibit A16 before you. You've seen that one before?
I have.
That's an email that you sent to Mrs. Barabolt on September 16th, 2013.
It is.
And what was your intent in sending that email?
This was to confirm with Ms. Barabolt that the information that she had provided met the identified or met the issues that were identified in the zoning violation notices for those 5 properties, the ones on Callanan, the ones on Rockingham, and the one on South Bryn Mawr Avenue, and that she had then addressed the violation and I was closing the violation notice.
So in effect, the violation notices for all 5 properties were withdrawn?
Withdrawn or closed.
Okay, thank you. Mr. Kachansky, have you seen Exhibit A17 before?
In preparing for tonight's hearing, I may have seen this as part of the documentations that we have on file.
I can represent to you that it was produced to me as part of the township's document production in response to the subpoena. Are you able to determine what property that relates to?
It says that this is a violation at 838 Conestoga Road, Rosemont.
And is that, to your knowledge, an existing student housing use?
I'm not sure.
Okay.
Okay.
You tell us, please, what Exhibit A18 is?
A18 is a series of enforcement notices under my signature to William Cartledge, the property owner of 838 Conestoga Road. Appear to be dated, all dated the same, September 17th, 2012.
And will you tell us, please, what the violations were that were stated in those letters?
Well, the first one is a formal warning that was issued under our rental housing ordinance, which outlined a series of other violations that were included as part of this. Those violations included the number of students living in the dwelling, violation from the property maintenance ordinance for weeds, violation from property maintenance and the sanitation ordinance for rubbish and garbage, and a violation notice regarding the rental housing ordinance.
So it's fair to say that at that point in September of 2012, you found a number of things that the property owner at 838 Conestoga was doing in violation of Radnor's code.
Correct.
Do you recall how those violation notices were resolved?
I do not.
And you don't know whether today 838 continues to be a student housing use?
I would again have to check our database to determine whether or not that is still a valid rental.
Fair to say that it still appears on the list that's Exhibit A12?
I don't know that this is an accurate list, and I don't know when this list was generated. Our rental housing list changes year to year. Properties come on and come off. Student housing, sometimes the numbers have dropped over the years.
The total number of such uses?
Yes.
Correct at least, though, that as of the time A12 was made, that 838 Conestoga was on that list?
I don't see 838 Conestoga. Okay. Yes, at whatever time this was, which I don't see a date on there, so I can't verify to a certain time period that this list represented. Again, and I don't see anything on here that indicates that that's a student property either.
Is there anyone at the township who would know whether this is a current list?
We would have to run a list off of our system and compare it.
Well, but I'm just saying, if you took this list,
If I
is there somebody who could identify whether it's a current list?
think we would try to determine where that list came from. And you had indicated that it was an Excel spreadsheet, but I don't know who created the Excel spreadsheet and what platform that they created that off of.
Okay. Take a look at that.
19, yes. Okay.
Have you seen Exhibit A19 before?
I'm familiar with A19, yes.
Was that agreement executed by the township and the property owner?
I believe it was.
Because this one's not a signed copy. You think the township does have a signed copy somewhere?
I would hope that the township would have a signed copy.
Okay. This agreement relates to the property at 840 Conestoga, correct?
Correct.
And there had been fair to say that there had been a series of violations issued by the township for that property?
Recollection, yes, that there were a series of violations at this property.
And this settlement agreement resolved appeals by the property owner of those violation notices?
Yes.
And do you remember how many such violations there had been?
I do not. But looking in through here, there are, it would appear, two different appeals that Mr. Hardy had filed. So that would have been in front of the Rental Housing Appeals Board for two different occasions.
And what was the nature of the violations that had been cited by the township?
I don't recall specifically.
Do you know if that property continues as a student housing use in the township today?
I believe according to the settlement agreement, it was allowed to. Whether or not it currently is, and the property owner continued to rent and renewed as a student under the 2015-2016 rental period, that I do not know.
It was your understanding of the agreement, however, was it not, that the agreement authorized the issuance of rental licenses to that property owner for both this academic year and next?
For the 2015-2016 rental period, I believe so.
And for up through 2017, right?
It specifically discusses 2015-2016 under the rental housing license, and then it talks about a probationary period in 2017.
And what the penalties would be if there were any further violations, correct?
I'm not seeing any penalties or provisions in here right off.
Probationary period, though, did extend through May 31st, 2017, right?
Correct.
Okay. That's all I have for now. Good hands.
Mr. Kachansky, let's start at A19 and go backwards. A19 is the settlement agreement?
Yes.
Okay. 840 Conestoga Road. Do you know if this was a licensed student home at the time these violations occurred?
Yes, it was.
And like you said, under the settlement agreement, after starting this year and carrying on, the homeowner was allowed to continue to rent to students if he so chose.
I believe so, yes.
And going back to A18, that is the cartilage.
May I interrupt?
Yes.
The paragraph B of the background of A19, which was signed by both the parties, so as the township recognized it, is a township student home use of the property is a lawful use that is legally nonconforming to various Radnor Township code, quote, code, close quote, regulations, including but not limited to zoning ordinance regulations pertaining to students' homes. So, you know, I presume that that meant you either satisfied yourselves, you know, that you satisfied yourselves that the basic use was a lawful non-conforming use under existing zoning, all existing zoning. Is that not true?
I believe it is, yes.
If I can direct you to A18. The cartilage enforcement, series of enforcement letters. At the time that these letters were issued, was this a legal student rental house?
Yes, it was. Otherwise, I wouldn't have been citing the provisions of the rental housing ordinance. If it was not a valid rental, I would have cited provisions under the zoning ordinance.
Okay. And by stating that it's a legal valid rental, it had applied for and received a license?
Yes.
And that these violations were because they were violating certain provisions that applied to student rentals, not to question whether or not it was a student rental?
Applied to student rentals and rentals in general.
And turning to A17. Date of this letter is October 2nd, 2003, is that correct?
That is correct.
At that time, the township had not enacted student rental provisions in the zoning ordinance, is that correct?
I believe that is correct.
When do you recall approximately or what year the student rental provisions were enacted for the zoning ordinance?
I believe that was in 2011.
And so in A17, the property owner was being cited for violating what?
Violation of the zoning ordinance definition of family, one other individual not related to the housekeeping unit. And that the property was found in violation with 3 unrelated individuals.
And concerning the 5 Barry Bolt properties that were covered by exhibits A16, A15, A14, and A13, to your recollection, were all 5 of those properties legal student rental houses?
Yes.
And they all had proper licenses at the time that you cited them?
They all had valid rental licenses.
And you were citing them for failing to comply with provisions that a student rental home had to meet, namely the number of students?
For that particular property, yes.
And once it was proven that they met the zoning requirements for a student rental house, the enforcement notices or enforcement actions were dropped?
For those properties, those properties were subject to the, prior to the zoning ordinance coming in, my understanding, prior to my arrival at the township, was that those properties were under the definition of 2 could be related, so that they weren't violating the family definition prior to it being a zoning ordinance, which is what grandfathered them in, and the violation notice was issued because they had not provided documentation, and then was subsequently closed out upon receiving satisfactory documentation.
And regarding Exhibit A12, there's, based on your testimony earlier, there's no way you can independently verify that this is a list of student rental houses?
I have no idea that this contains properties all within Radnor Township or outside of Radnor Township.
And you have no idea if it lists student rental houses, all or some of them in the township?
I do not know.
And you have no idea what date this list was produced?
There's no indication of any date of when it was produced or how it was produced.
That is all I have for now. I will be recalling Mr. Kochanski for the township's case in chief. Thank you.
I'd like to take a short break, maybe 5 minutes. One of the things I can do is try to pull up that Exhibit A12 on the iPad, and possibly it'll give us a firmer indication of when it was made, which I think will clear up any ambiguity about what it is and when it was issued.
Sure.
All right?
We'll take a recess till 9:30. right, it is 9:30. Council?
I may have just about 2 more minutes trying to get this thing.
Okay.
You're not, can't find, you're not gonna find it, everything is PDF for some reason. Even though I have Excel on here, it's not coming. So what I'm gonna do is send it.
All right, we are back in session.
Mr. Kachansky, returning for a moment to Exhibit A19, you spoke a few minutes ago in response to Mr. Nelson's question about the fact that this property at, this was the 840 Conestoga Road property, that this property had been demonstrated to be a lawful nonconforming use. Do you recall what you did to satisfy yourself that that was the case?
Not specifically, no.
Do you have a practice in determining lawful nonconforming uses as to what information you consult to decide that?
Generally, we'll take a look at the property file, both the electronic and Laserfiche, the ComDev server and the paper file, as mentioned earlier, and look at the history and what communication and correspondences and files are in that, and then I'll consult with our solicitor.
Would you attempt to determine whether the property was nonconforming as part of that practice? Would you determine whether it was nonconforming as to the underlying zoning or only to the student housing ordinance?
It would depend on the issue as to what we were looking at for nonconformity and what was being posed to us at that point in time.
So if you're looking at whether a student housing use is a nonconforming student housing use, what would you look at?
For a student housing use, nonconforming in terms of what?
A nonconforming in terms of prior existence before the passage of the student housing ordinance.
As a valid student rental prior to the enactment of the zoning ordinance.
Correct.
I would look at the files for the rental leases, or I'm sorry, the rental renewal licenses, and see historically what is in the file for that.
The rental housing ordinance goes back only to about 2001, correct?
I don't know specifically.
Did you ever have to make a determination as to whether a student housing use was a lawful nonconforming use based on its existence prior to the year 2000?
Not that I can recall.
Okay, that's all I have.
Regarding
Exhibit A19 to 840 Conestoga Road. Did you make that determination, or was that determination of it being a legal nonconforming use already made when you first were hired by Radnor Township?
I believe this was an existing student rental upon my arrival here at Radnor Township.
So you weren't the one who made that determination, that had already been made?
Correct.
Thank you, that is all.
Nothing further from Mr. Kachansky.
Thank you, sir.
Thank you.
As our next witness, we call Sarah Backenstow.
I do. Sarah Teresa Backenstow, SarahTeresa Backenstoe. Thank you.
Sarah, where do you live right now?
I live at 220 Lowry's Lane
How long have you been living there?
since June 1st because I worked at school this summer, so I lived here this summer.
You go to Villanova?
Yes.
What year?
I'm a senior.
And what's your major?
Communications, and I have a political science minor. Political science minor.
During the period of time that you've been living at 220 Lowry's, have you had any problems with the police?
No, not at all.
Do you know your neighbors over there?
Yes, we know. So the ones directly next door to us, they're a family, and they have an 8-year-old girl named Sarah. She's come over to our yard a few times and said hi. She had a lemonade stand last week. We willingly participated, and we gave her candy and stuff for Halloween.
How would you describe your relationship with all your neighbors?
I would say extremely positive and friendly.
Have any of the neighbors expressed any discontent with the way you're conducting yourselves over there?
No.
How many roommates do you have?
4, including me. So there's 5 of us total.
Okay. And no complaints whatsoever from anyone?
No.
Okay. That's all I have. Wait a minute, Sarah.
Ms. Backenstow,
Mr. Nelson may want to ask you a few questions.
where is your familial home?
I'm from Bethesda, Maryland, but
Okay.
are you asking me where this house is?
No, I was
Okay.
wondering where you came from.
Oh, no, I'm from Bethesda, Maryland.
Okay, thank you. No other questions. Hold on one second. Sorry, Ms. Backenstow. When you first signed the lease for this property, were you provided any sort of notice that they did not have zoning approval or permits to rent this to students?
We were told that it was in the works, but that it wasn't that big of an area of concern, and it's not uncommon for Villanova students to be in situations like this.
Okay, thank you. That is all.
Mr. Chairman, I got a couple questions. Sarah, did you sign a lease for the property?
Yes.
And did your 4 roommates sign a lease for the property?
2 of us did.
So only 2 people signed the lease?
Yes.
Did you ask at the time why only 2 of you were signing the lease?
No, we were told that that was how it was, and that's how a lot of other people do it too at school, so it didn't seem that strange.
And do you know why people do it that way at school?
Yes, I assume that it's because of Radnor Township laws.
Thank you.
That's all we have.
You want, there's no way we're going to be finished tonight.
You're not,
Do you want us to start?
we're not, nothing on constitutionality,
Okay.
just related to the variance issue, which is
Okay.
what, yeah, excluding discriminatory.
Discriminatory enforcement. Now, I think most of our testimony at this point in time is going to be having to constitutionality.
Great, thank you.
So, that, yeah. Yes. I mean, sorry, hold on one second. I'm sure there'll be some testimony that Mr. Kachansky, which will bleed over in discriminatory, but it's going to take more time for us to separate it out, and we'll be repeating ourselves instead of just doing it all at once. But I think the vast majority of his testimony has to do with, the vast majority has to do with just straight constitutionality.
It's 9:40. I don't know what your pleasure is in terms of how long you want to go tonight, but we're
Well,
prepared
as I
to
said,
press.
we're going to decide this matter first, this issue first, and then we'll,
You have nothing to present on traditional variants or special exceptions, i.e. that, you have a unnecessary hardship or, or anything like that.
Well, the hardship, at least in the immediate sense, is that we have people living there who we'd like to have continue to live there through the end of the school year. There's no hardship relating to features on the property, physical features on the property that necessitate it being used for this purpose. It's a single-family dwelling and theoretically could be used for that purpose. We can't contest that. But our concern is for the welfare of the girls who are living there, and our interest is in ensuring that their residency there is not disturbed during the period of time they remain in school. So we have no arguments on hardship, and with regard to a special exception, we clearly don't meet the proximity requirement, but then again, neither do most of the properties within, most of the many properties that are within 1,000 feet of ours.
yes. With that, okay. With that, John, why don't you get the mic? With that, I'll open the floor up if anyone wants to come up and be heard on this matter
Mike,
before we
Can we
deliberate.
finish with testimony before we get to that? I mean, I
I
think.
thought you were done.
Well,
You said you were
I'm
done.
done on those issues, yes, but rather than have the board decide this piecemeal, I'd prefer that we get all the evidence in before the board decides any of these issues.
Well, again, I already told you how the process would work. The board is aligned on that, so that's what we're going to follow. After this, we will have an executive session. We haven't had a chance to talk to our solicitor about, kind of the constitutionality issues, so we're not going to get there yet, no matter what. So let's close out the case you just put on.
Okay, well, we did close that out.
Yes,
and
you
I think
did.
a lot of our evidence did relate to the constitutionality issue, particularly on an as-applied basis. So we've already entered that realm. If you want to continue with testimony, we'd be happy to keep going for a little while longer, but that's your pleasure.
Thank you. Is there anyone who would like to come up and?
Before we get to that point, I'm sorry, do you want any testimony specifically regarding this issue of constitutionality?
Guys,
as
stop
to
it.
whether or not
No.
as to whether or not you reached the issue of constitutionality?
No,
Okay.
I do not. Not right now. Yep, let's close this out. Again, if there's anyone who would like to come up and share anything with the board, we'd be more than happy to hear you. Okay, with that, I'll open it up to discussion amongst the board.
Mr. Chairman, as was evident, there's no evidence to justify a special exception. There's no evidence to justify traditional variance. There is not sufficient evidence to demonstrate the basis for a variance by estoppel. Based on my understanding and recollection of the prongs, there's a reliance component there. There was never any evidence suggested that in reliance upon any imputed failure of the township to enforce, that there was any detriment to the property owner. There's no hardship. The property certainly stands as a capable single-family home. And the circumstance involving the students who are residents is unfortunate, but they have a contract with the property owner and that contract presumably can provide whatever recourse is appropriate if there is a breach of contract. We do not have a motion before us right now, but I see no basis on the evidence that is before us to grant any relief.
I think my, my reaction was similar. The specific issue we're talking about is whether there was evidence to support a variance by estoppel. A variance by estoppel still is a variance. You need to show hardship. I didn't hear any evidence of a hardship. I didn't hear any strong evidence that somehow this property owner was singled out as opposed to the township's normal procedures for pursuing violations of the student housing ordinance. So at this point, I would make a motion to deny the request for a variance by estoppel.
May I be heard briefly on this, very briefly, before you vote on the motion?
Mr. Chairman, we've heard 3 hours of testimony in September. We've heard 2 hours and 15 minutes of testimony here, and we still need to discuss the final issue. We asked counsel twice whether he was finished.
I was finished with the presentation of evidence, but I didn't waive argument. There is really just one point I want to make in counter to something that the board suggested.
I think we're in discussion mode here, so unfortunately, no. We're going to continue discussion and make a motion.
Well, you know, this relates to the estoppel issue. There's nothing in the record showing that Mr. Fisher was ever advised at the time of the 2004 letters that he needed a rental license. Nothing in there that
Okay.
suggests that.
We understand you may disagree with us. We understand that.
Well, it's just
Okay.
a point that I wanted to put on the record because there's nothing
I
showing
think you already had that
he
on the
was
record, but
advised of that.
thank you. John?
I don't have anything to add from the vice chairman or
motion.
Mr. Nagel's motion. I'll second it.
Great. Any debate? Okay, all in favor?
Aye.
Aye. Any against? And any abstentions? All right, so denied. We are going to take a 10-minute recess to have an executive session. And we'll come back and give you our thoughts on the next issue of constitutionality. We are back in session. Appreciate your patience. We did have to talk through a couple issues with our solicitor, but I think at this point, one of the board members would like to make statement/motion.
Mr. Chairman, members of the board, based on the evidence that we had presented to us at the September meeting and this evening, I'm convinced that without regard to a potential determination regarding the constitutionality of the student housing ordinance, that the applicant won't be entitled to relief because of the acknowledged failure to comply with the underlying restrictions associated with the R4 district. So to entertain the question regarding constitutionality, I think only would be in anticipation of issuing an advisory opinion. And I don't think that in Pennsylvania, zoning hearing boards are expected to be in the business of issuing advisory opinions. So it would be my motion that for that reason, we do not proceed with hearing the constitutional question.
Thank you. Can I get a second?
I'll second the motion.
Is there any discussion amongst the board?
No discussion.
None. So all in favor?
Well,
Yep.
I do think that it would be appropriate to hear from council if they want to provide any perspective on the question.
That's great. Assuming it's brief. So, council like to present anything before we make our vote?
Who would you like to go?
Welcome to that first shot.
Have fun.
Very briefly, we support this decision. We don't think the applicant could receive any relief here. It is on. Am I not? There you go. I'm not talking to it completely. The applicant would not receive any relief even if they were able to prove the student rental provisions to be unconstitutional because they could not meet the definition of family. As was shown in the hearing today with one of the applicant's exhibit, before we adopted, or before the township adopted the student rental provisions in 2011, it was common practice for the township to enforce the definition of family against student rental houses that rented to more than two unrelated people. And so it's the township's position that we agree with this decision. We think it's the right decision. We think that no relief could be granted in this case, and thus any decision on the constitutional issue would be advisory and impermissible under the MPC. Thank you.
Thank you, council.
Well, first of all, there is a principle, and I have no cases before me to give to you, although I probably can find a couple if you want me to, that constitutional issue is an independent and freestanding issue in most cases. And again, the only ordinance that we were cited with violating was the student housing ordinance, and we have the ability to challenge that on the application of that ordinance on a constitutional basis without necessarily being able to demonstrate that we could comply with the underlying R4 zoning. And furthermore, I think you've had testimony tonight that on at least one of the properties we talked about, there was an acknowledgement by the township that the property did not comply with R4, and yet it was allowed to continue as a student housing use despite violations. So I understand the board's motion, but I don't think that the premises for it are established as a matter of law. And I believe we should have the right to pursue the constitutional issue by the presentation of any additional evidence. And particularly, I certainly wanted to hear what the township's evidence is on that. We presented a significant amount of evidence on inconsistent enforcement, and I think that goes a long way to establishing that the ordinance is unconstitutional as applied to my clients in this situation. So I think that we should continue with the constitutional part of the case, and that the board should reserve judgment on that until it's heard all the evidence.
Thank you.
Thanks.
Thank you, council. So now entertain a vote on the motion that was brought and seconded. All in favor?
Aye.
Aye.
Any against? And any abstentions? So the motion is carried. With that, I'll conclude tonight's hearing. Our next hearing will be on Thursday at 7:30, our normal November hearing.
Just to clarify, this ends this matter. A decision will be issued in 45 days, and we're not going to have a hearing on Monday, November 30th.
That is correct. This matter is closed.
Thank you.